All right, everybody. Thank you for joining us today. My name is Alyssa Barton, and I'm with Puget Soundkeeper Alliance. I'm the policy analyst and executive coordinator here. Um, Folks are currently on mute, um, but you can communicate with us through the Q&A if you've got questions. Um, we'll be responding to the questions at the end unless it's clarifying questions. So thanks so much for joining today. This is Speak Up for Clean Water, the Dirty Water Rule 101, what it is and why you should oppose it. And our goal today is to just provide folks with kind of a high-level overview of the Clean Water Act, the Dirty Water Rule, and equip you with the information that you need to submit public comment by the April 15 deadline. The goal is really to generally equip folks to state their opposition to the Dirty Water Rule and articulate issues with the rule, not to really get too deeply into the weeds or to provide technical legal analysis. So a little bit of housekeeping up front. For those who are just phoning in, we're recording the webinar and it will be made available by the end of the week. We'll post it on socials and we'll also email it out to participants. You can also visit our WOTUS or Waters of the United States page at pugetsoundkeeper.org, and the link will be posted there as well. So we really encourage you to ask questions. Again, use that Q&A, and with that, we'll go ahead and get started. So I'm going to talk a little bit about Puget Soundkeeper first for those of you who don't know us, but I'll keep it short. The Clean Water Act is really the bedrock of our organization. Soundkeeper's mission is to protect and preserve the waters of Puget Sound. And to meet this goal, we engage in 3 types of programmatic work: monitoring and enforcement, policy and civic engagement, and stewardship and education. And all of our work is grounded in the Clean Water Act, which is why we care so much about it and which is why we're here today. The Clean Water Act includes a citizen suit provision that allows citizens and organizations to step in and enforce the Clean Water Act, stopping illegal pollution when agencies don't. So we actively patrol the waters of Puget Sound and monitor for pollution, and we enforce the Clean Water Act through legal action. We've filed over 200 legal actions, and we have nearly 100% success record in Clean Water Act cases. We couldn't do this without the strong water quality protections built into the Clean Water Act, and without our members and supporters who are willing to act as citizen enforcers and witnesses. So the Clean Water Act is really essential. The Clean Water Act was passed in 1972 at a time when the country finally got fed up with the amount of pollution in our waters. Physical debris and chemical pollution was so common, the Cuyahoga River actually caught on fire a dozen times before that big fire of June 22nd, 1969 that so many talk about and have heard about. It was really an iconic blaze that spread to Lake Erie. The objective of the Clean Water Act is to restore and maintain the chemical, physical, and biological integrity of our waters. So we had big goals when we passed the Clean Water Act. The Clean Water Act regulates the discharge of pollutants into United States surface waters, including lakes, rivers, streams, wetlands, and coastal areas. And the text of the statute reads that it is the national goal that the discharge of pollutants into the navigable waters be eliminated by 1985, with an interim goal of water quality that provides for the protection and propagation of fish, shellfish, and wildlife, that provides for recreation in and on the water, to be achieved by July 1, 1983. So you can see that we've got a ways to go. So what waters are protected by the Clean Water Act? That's the crux of why we're here today. The Clean Water Act protects navigable waters of the United States, but what are these navigable waters? What are these waters of the United States? A conference report from the Senate debate back in the 70s that overrided the president's veto of the Clean Water Act discussed how Congress members fully intended that the term navigable waters be given the broadest possible constitutional interpretation. Navigable waters was intended to mean all the waters of the United States, not just waters that are navigable in the sense you can sail a boat on them. But after passage of the Clean Water Act, folks debated the meaning of waters of the United States. The rules and interpretations by the courts and by the EPA, the Environmental Protection Agency, which is the agency that implements the Clean Water Act, changed over time. I'm not going to get too deep into the details of the different categories of waters today, but I will talk a little bit about some of the big decisions. One landmark case interpreting the definition of waters of the United States was Rapanos versus United States, a 2006 Supreme Court case. In Rapanos, the dispute was over whether the Environmental Protection Agency could regulate isolated wetlands under the Clean Water Act. The court issued a fractured opinion with no majority. It's a 9-member court, and it's split 4-4-1 with different interpretations of how to determine if a wetland should be protected by the Clean Water Act, if it should be a waters of the United States. In Rapanos, Justice Scalia, supported by 3 other justices in a plurality, which means more than any other but not a majority, argued that waters of the United States should only protect relatively permanent, standing, or continuously flowing bodies of water. Justice Kennedy, concurring in this judgment, proposed another test that's commonly referred to as the significant nexus test. 4 dissenting justices would have left EPA's definition in place, but they would also uphold protections for waters that satisfied either Scalia's test or Kennedy's test, so a much more expansive definition. Justice Kennedy's significant nexus test would protect wetlands that were had a significant nexus to waters traditionally considered navigable. And Scalia's view was much narrower. Despite the disagreement on specifics, even the narrowest provisions in Justice Scalia's opinion in Rapanos recognized that in passing the Clean Water Act, Congress intended to cover a much broader set of waters than had earlier been the case, or that was traditionally considered navigable. So what happened after this Rapanos case? After Rapanos, courts across the United States either adopted Kennedy's significant nexus test to determine if a water should be protected under the Clean Water Act, or they adopted an either-or rule where it was protected if it either met Kennedy's test or Scalia's test. The EPA also adopted Kennedy's significant nexus test. So we'll fast forward to 2015. Folks on one side were debating that coverage should be narrowed. Folks on the other side debate that coverage should be broadened. In 2015, the EPA published a rule to further revise the definition of waters of the United States, and it's generally referred to as the Clean Water Rule. The agencies involved made extensive factual and legal findings in support of the Clean Water Rule. They used what they found to be the best available peer-reviewed science, public input, and the agency's technical expertise to implement the Clean Water Act. They first affirmed that the significant nexus test that Kennedy developed is the appropriate test for determining which waters are waters of the United States, based on case law and extensive scientific analysis and input. They also prepared a very detailed science report, which was used to characterize the nature and strengths of the connectivity between upstream and downstream waters. In developing the Clean Water Rule, EPA held over 400 public hearings and analyzed over 1,200 peer-reviewed scientific articles. That being said, the Clean Water Rule was flawed in a couple of ways, which are outlined on this slide. It failed to protect some types of waters that should be covered by the Clean Water Act, and that's why Soundkeeper challenged this rule in court. But it should be noted that many polluters also challenged the rule and believe that it went too far, protecting too many waters. However, in 2017, things changed yet again. On February 28, 2017, President Trump issued Executive Order 13778. It directed the EPA to review and repeal or revise the 2015 Clean Water Rule. In response, the EPA moved forward with several rulemakings. They proposed a rule to take step 1 of Trump's 2-step repeal and revise process back in 2017. So in July 2017, EPA proposed a final rule that would repeal the 2015 Clean Water Rule. Then EPA did a supplemental repeal of the rule in 2018. The EPA also tried to delay the implementation of the Clean Water Rule. And in February of 2018, they finalized a rule to add a 2-year applicability date, delaying applicability of the Clean Water Rule until February 6, 2020, meaning the Clean Water Rule wouldn't go in effect until February of 2020. They basically wanted to delay the rule and prevent it from being implemented until they could get rid of it. And now we're seeing the final step in the process, or what could be the final step, which is the rescission and revision of the Clean Water Rule. This new revised rule was formally published on February 14, 2018, and it's pretty bad. It's widely being called the Dirty Water Rule, and that's why we're here today. So just in case you're wondering about this Clean Water Rule from 2015, while the current Dirty Water Rule is being prepared, the Clean Water Rule is still being debated in court. In November of 2018, the 2-year delay rule that came about in February of 2018 was found arbitrary and capricious by the Western District Court of Washington in Soundkeeper's original Waters of the United States challenge. And the U.S. District Court for the District of South Carolina also knocked down the 2-year delay rule. So in effect, the 2015 Clean Water Rule is now in effect in 22 states, DC and U.S. territories. But in another 28 states, the definition of waters of the United States is one that was promulgated by EPA in the 80s because it's being debated in court. So the Dirty Water Rule, why we're here today. There is currently a comment period that lasts through April 15, so just a few more days. Still time to get in your comments on this Dirty Water Rule. I've listed out some of the changes here on this slide, but this is not all-encompassing. This doesn't cover all of the changes. The rule is very long and pretty complicated, but this is sort of a high-level summary of some of the things that they're trying to do. And just to be clear, these changes will not only change pieces that were in the 2015 Clean Water Rule. These are changes that will roll back protections that have been in the Clean Water Act from the time of its inception. So it strips protections for interstate waters, excludes many tributaries, removes agency discretion to evaluate some waters on case-by-case basis, basically that Kennedy test, which came out of the Rapinos case. It excludes most ditches from Clean Water Act protection, removes protections for many lakes and ponds, excludes many wetlands, groundwater, stormwater control features, wastewater management features, recycling structures, waste treatment systems, strips protections for all ephemeral and intermittent waters, and excludes artificial lakes and ponds and uplands. I'll talk a little bit about the ephemeral and intermittent waters a couple of slides down, but I would flag that because so many of our waters in the Pacific Northwest do not flow year-round and could be impacted by this rule. So I've talked a little bit about the different definitions of waters of the United States, what should be covered, what shouldn't. Really, some of these lines are a little arbitrary because all waters are connected. Scientists know this. This slide just shows the hydrologic cycle of our water from oceans to water in the atmosphere, precipitation, back down to groundwater, and replenishing our stream flows and freshwater sources. We know that all waters are connected. The science report that was produced during the Clean Water Rule rulemaking process contained 5 major conclusions about the connectivity of waters. They concluded that all tributary streams exert a strong influence on the chemical, physical, and biological integrity of downstream waters. They concluded that wetlands and open waters in riparian areas and floodplains are chemically, physically, and biologically integrated with rivers via functions that improve downstream water quality. They concluded that wetlands and open waters in some landscapes also provide numerous functions that benefit downstream water integrity. that connectivity between tributary streams and wetlands and downstream jurisdictional waters occur along a gradient, um, and that while the connectivity of stream channels and wetlands to downstream waters is unequivocal, the connectivity of certain waters is more variable and difficult to address categorically. So it's hard to draw lines between what should be covered and what shouldn't based on this connectivity assessment. And they also concluded that incremental effects of individual streams and wetlands are cumulative across entire watersheds. So they must be evaluated in context with other streams and wetlands in the same watersheds, the same systems. So I borrowed a few slides here from our partners over at Waterkeeper Alliance. Puget Soundkeeper is a member of the Waterkeeper Alliance, one of the founding members. This just sort of is a gut check. This rule could remove Clean Water Act protections from millions of miles of waterways. It could impact tens of millions of acres of wetlands. And the definition could potentially accelerate the extinction of more than 75 endangered species. In Washington State, I believe we have 15 subspecies of salmon or distinct categories of salmon that could be impacted, that are threatened or endangered. And again, a lot of the waters here in Washington State do not flow year-round. They are ephemeral or intermittent. They flow as a result of precipitation or glacial melt. And so this could be very, very damaging, very frightening exclusion. This is just another impact slide to consider. Nearly 2 million miles of our streams outside of Alaska are intermittent or ephemeral. There's some percentages listed for states in the arid West. 85% of streams are ephemeral in Nevada, 66 in New Mexico, 51 in Arizona. I saw a stat indicating that Oregon is at 71%. These are all waters that risk losing protection under the Dirty Water Rule. There's approximately 20 million acres of isolated wetlands in the continental US that risk losing protection. And unfortunately, about 70% of the waters assessed by EPA are already classified as threatened or impaired. We haven't fully assessed all of the waters that we know of in the United States for pollutants. But those that we have assessed, 70% are already threatened or impaired by pollution. So now is not the time to be rolling back which water should be protected by the Clean Water Act. And yet the proposal would strip federal protections from at least 18% of streams and 51% of wetlands nationwide. And that's an Army Corps stat. I think the link should be active in our presentation when we share that. Not sure if it's active on the screen, but. So why we're here today, to give a basic comment writing 101. I'll note that this isn't legal advice. A lawyer would be searching for case law and applicable statutes to make legal arguments. And likewise, experts or those with appropriate professional backgrounds might be scanning through the records, citing to the scientific literature for their technical conclusions about the rule. This advice is basically for the layperson to be able to submit comments about your specific objections to the rule, but you can get into the weeds as deeply as you so desire. For those who might be writing a public comment for the first time, think of this as a 5-paragraph essay, which can be expanded on. Your basic 5-paragraph essay starts with the intro, who you are and why you care, followed by 3 body paragraphs and a conclusion. In the conclusion, you can ask for the alternative, what you are requesting EPA to do. 3 strong tips would be to pound the law, pound the facts, and then pound the table if you've got no more law or facts to pound on. Making value statements, talking about why you personally connect with clean water, why you care about it, why it matters to you. If you can think of a local water near you, a lake that you like to jog around or take your dog for a walk near, or just the fact that you live near Puget Sound if you're in the Washington area, or a local stream that you like to fish from or swim in. So clearly organizing your comments also important. Clearly identify the issues in the proposed regulation on which you're commenting, the specific pieces and exclusions. And put your strongest arguments up first, weakest last. And again, I would use specific examples, either from the science if you have a technical background, or from your personal experience, water bodies that you are concerned about. Err on the side of inclusion. And when we say suggest alternatives, it's our perspective that this rule should be withdrawn. The dirty water rule should be withdrawn, and essentially the clean water rule should be allowed to work its way through the courts, because the dirty water rule has not followed the appropriate process, and it's also it constitutes scientific and policy backsliding on Clean Water Act protections that have been in place for decades. So with that, I'd like to open it up to some questions, as I'm sure we have some. And again, if you could put your questions into the Q&A, I've included the link on this final action page to regulations.gov where you can submit comments. And I'm seeing a question about exclusion of groundwater. So the question from Amy is, exclusion of groundwater seems very important, but I haven't seen this discussed in most activist materials so far. Thoughts? Groundwater quality and quantity linked and both very important in rural areas in Washington. So absolutely, groundwater is very, very important. That is one of the pieces that we're very concerned about. Drinking water sources are also protected under the Safe Drinking Water Act. And there are other federal regulations that protect water, but not in the same way that the Clean Water Act does. So I see a second question from Teresa that I live 45 minutes away from Lake Erie. The citizens of Toledo got rights for it. Is that not a good example to use then? So in response, I would say I'm not applying a legal lens to whether or not the lake would be protected, but I would just say, for those of you writing comments about the waters you care about, just say, I'm concerned about this water and worried that it could lose protection, rather than opining that it might. All right, we've got some other questions here. One question from 1209 from Ruth, can I access the recording later? Yes, we are going to circulate an email to attendees that should include the link, and it will also be available on our website and in our socials if you want to check Soundkeeper's socials. Oh, looks like that was answered too. Let's see. So Lisa Friend asked, will you discuss ecological services and environmental services provided by wetlands as well? Thank you. So yes, wetlands absolutely do provide a lot of environmental and ecological services, but obviously we haven't really gotten into that today. Wetlands are critical, and many are already polluted or degraded. But this is more about the rule itself rather than those specific services. Second question here from Lisa was, I'm guessing dirty water rule is not the proper way to introduce the discussion. Could you please give us the formal title of the document you're commenting on? And I can definitely look that up. It, I believe, is being called Revised Definition of Waters of the United States. And if you take a look at that link, which I believe should be clickable on the page, it should take you right to the Federal Register link to comment. And I think that also answers Nathan's question, what is the actual name of the proposed rule change, which is Revised Definition of Waters of the United States. Great. All right, do we have other questions? I have a question from Amy. What are Soundkeeper's plans for legal action? Not really at liberty to talk about that, although we are really concerned about this, and we are submitting comments. Our attorneys over at Earth Justice are preparing a technical and legal comment letter, and should it move forward, there is a likelihood that there will be some lawsuits around it. I have a question from Eloise. What's the likelihood of this new dirty water rule passing and moving forward? That's a really great question, and I'm really not sure. I can't really tell you. It looks like from some of the other rulemakings we've seen that EPA is moving forward with them and finalizing them. So it's likely that it will. That the dirty water rule could move forward and be codified, and then challenged in court. And then we have a question from Sarah about issues with the link. Not really sure. If you still can't, yeah, we had a response from Julie. Use the Soundkeeper page to submit comment. All right. Let me see if I have any other questions trickling in. Other than corporations, we have a question from Teresa. Who will benefit from changes to this? Who would possibly want this? Anyone? That's a really great question, Teresa. And I really can't say. I really can't say. This would be very harmful for public health, harmful for folks that use the water, harmful for folks that like to recreate on or near water, for folks that like to eat fish from our water, yeah, I would be speculating as to who else might benefit. Question from Eloise, will EPA extend the deadline for public comment? That's a great question, and I highly doubt it at this point because they haven't already. Again, that deadline is April 15. So make sure to get your comments in before the deadline. All right, well, with that, the webinar has been recorded and the link will be available soon. So you can find us on Facebook, Twitter, or Instagram. We'll post there. It'll be on our website as well. And I believe we'll also be sending out that email after this wrap up with the link. If folks want more information about other areas of our work, upcoming events, actions, and volunteer opportunities, visit our website, PugetSoundkeeper.org. And if you'd like to reach me for questions, my email is Alyssa, ALYSSA, at PugetSoundkeeper.org. I'm sorry I didn't put that up on the slide. But you can also call us here, 206-297-7002, for more questions or concerns or feedback. So thanks everyone for joining in today.